Welcome to the third of Tanfield's short series of 4 webinars dealing with matters commonly found in cases involving contested probate and disputes arising in the administration of estates. I'm Charles Joseph, and I'm joined by Adrian Carr, Gwyn Evans and Olivia Murphy. This webinar deals with the Larke and Nugus process, Civil Procedure Rules 57 and 64, Beddoe orders, and the removal and appointment by the Court of Personal Representatives. Adrian is going to start us off by talking about the case of Larke against Nugus.
Many thanks, Charles. If we can move on to the next slide. Before moving on to Larke and Nugus, I just wanted to address 2 things, and the first of those is searches for grants of probate, and the second is medical evidence. But first, just to deal with probate searches. You can carry out 2 different types of search. The first is a probate search, and a probate search is used to discover whether a grant of probate or administration has already been made of the estate of a deceased person. To do this, you can go to the gov.uk website, find, download and complete form PA1S to search for a probate record by post, and any probate will be sent to the address you've given on the form. It costs £1.50 to do a search by post, and this will include a copy of the probate record and the will if there is one. You should get a response to your request within 4 weeks. Secondly, there is the standing search. You can enter a standing search so that you will be notified when a grant of probate or administration has been made. Once again, you can download the same form, the PA1S, from the gov.uk website and ask to be sent a copy of a probate if it's granted within the next 6 months. This is called a standing search, and it costs £10. It lasts for 6 months, as I said a moment ago, and you can extend the standing search for a further 6 months. If we can move on to the next slide, where I wanted to deal with medical evidence. Very often in probate disputes, or where there is the possibility of there being a probate dispute, there is a question as to whether the testator had testamentary capacity or whether they knew and approved the contents of the will. Where such a dispute arises, it's often very helpful to obtain the testator's medical records and to obtain those records as soon as possible. Under Section 3(1)(f) of the Access to Health Records Act 1990, the testator's personal representatives, or any person who may have a claim arising out of the testator's death, can apply for the testator's records. A charge will be made which is proportionate to the volume of records requested, and the authority will give you an estimate before providing any of the copy records. In England, the organisation which provides the records is England Primary Care Support, and it is allowed 40 days from the date that a correctly completed form together with the appropriate identification document and fees are received. And it must provide a copy of the medical records within 40 days. I should just say that obtaining those medical records should be regarded really as a starting point, because Primary Care Support England stores a patient's GP records. That will of course include the GP records themselves, and that will usually include letters and reports from other medical professions, be that consultants, surgeons or other care providers to whom the patient has been referred for treatment. You may have to apply to the hospital or other place where the patient was actually treated to get more detailed records of their treatment. Where a testator executed a will while in hospital or in a care home, the patient will usually have further medical records being retained by that hospital or care home. Where the testator executed the will shortly before he or she died, it is very often helpful to have access to the hospital records or care home records for details of things like the testator's medical condition from hour to hour, what medication the testator had received, and perhaps most importantly, who visited the testator and how long those visits lasted. Very often, care homes will retain a logbook of visitors giving the time they came and the time they left. It's very often useful to tie up the visitor times in the logbook with the times when the testator received medication and when reports were made on their notes about their medical condition. If we can move on to the next slide, where I look at Larke and Nugus statements. Very often in probate disputes, a question arises as to what the duty is of a solicitor who took instructions for and prepared a will to disclose those instructions and the will where the validity of that will is later challenged. The solicitor's evidence will often be of crucial importance in court, but more often than not, the person seeking to uphold the will is going to be very anxious to prevent the person seeking to challenge the will from getting hold of those documents, and will try to induce the solicitor to not disclose those documents to the person challenging. On this point, I would observe that in general, the death of a client does not extinguish privilege. That privilege continues after death and attaches to the communications which carried out before death between the client and his solicitor. If we can move on to the next slide, we can see that in the case of Larke and Nugus, the Court of Appeal held that privilege cannot be claimed by one person claiming under a deceased will as against another person having a similar claim in respect of matters communicated by the deceased to the solicitor during the lifetime of the deceased. While it is clear that the privilege of a testator on his death does pass to his executor, and that it is the executor's duty to maintain that privilege against persons claiming adversely to the estate, where there is a contest between two parties who are both claiming under the estate, under the estate of the testator, it would seem to be a mere arbitrary rule to hold that the privilege belongs to one of them rather than to the other. And in those circumstances, neither party can claim privilege to those documents. If I can move on to the next slide. Following Larke and Nugus, the Law Society provided guidance, and the Council of the Law Society has decided that where a solicitor was responsible for drawing up a disputed will, he should make available a statement of his evidence regarding the execution of the will and the circumstances surrounding it to anyone who requests such a document, whether or not he acts for those propounding the will. The statement must be made available free of charge. Usually, the solicitor should also make his file, the will file he kept when he prepared the will, that should be made available as an exhibit to the statement. If we can move on to the next slide. Another question which frequently arises prior to the issue of proceedings is getting hold of the will itself. Of course, after the proceedings have started, the parties will have had to have filed witness statements of testamentary documents, and so all parties will have copies of the will. But before a party has started an action, that process hasn't been carried out, and one party may have a copy of the will and refuse to provide it to the other. In that case, the party who wishes to obtain access to the will may make an application ex parte for a subpoena in the principal registry or a district probate registry, supported by affidavit setting out the grounds of the application. The subpoena may command the document, the will that is, to be brought into the principal registry or a district registry as the court may direct. If it is satisfied on the matters set out in the application, then the court will order that the subpoena be issued. The subpoena must be served personally on the person being ordered to bring in the will, and it must be endorsed with a penal notice. Lastly, on obtaining testamentary documents, it's doubtful whether a subpoena can issue for service outside the jurisdiction. If we can move on to the next slide, we look at pre-action protocols. No specific pre-action protocol is currently in force for probate claims. So in that case, in the absence of any specific pre-action protocol, the general pre-action protocol, pre-action practice direction, pre-action conduct and protocols applies. This practice direction is designed to enable parties to settle claims without the need to start proceedings, and to support the efficient management of the court by the court and the parties of the proceedings that cannot be avoided. So it's important to note that the pre-action protocol has two purposes. First of all, to avoid parties having to issue in court at all, and secondly, if they do have to issue proceedings in court, to ensure that they have all the documents available, all the relevant documents available, and each party knows what the other side's case is, so that the issues are as far narrowed as possible before the start of the proceedings. ACTAPS offers a document that can be used as a pre-action protocol, and that's suitable for many of the situations that arise in the context of probate disputes, and their pre-action protocol is available from their website. Lastly, on this point, a failure to comply with the practice direction can result in the proceedings being stayed until the relevant steps have been taken, which of course will incur additional costs for the client. But more particularly, a failure to comply with the pre-action protocol is likely to result in adverse cost penalties to the person who has failed to comply. So as a matter of practice, it is a good idea to comply always. If we can move on to the next slide, just dealing with the specifics of what you need to do under the protocol. First of all, the onus lies on the claimant to send a letter for action, in which the claimant must give concise details about the claim. That letter should include, first, the basis on which the claim is made, secondly, a summary of the relevant facts, and thirdly, and perhaps most importantly from the defendant's perspective, a summary of what the claimant wants from the defendant, so that the defendant can understand and investigate those issues without needing to request further information. Very often it is useful to send copies of documents which the claimant intends to rely on in any proceedings with the pre-action protocol letter, so that the defendant has all the information he needs to respond. So then the onus switches to the defendant, who is required to provide a full response, in which the defendant will either accept the claim in whole or in part, or state which parts of the claim are accepted and which are disputed, and the basis of that dispute. If the defendant intends to bring a counterclaim, he must provide information in relation to the counterclaim in his response in the equivalent way to the way in which the claimant has set up his claim in the letter before action. The defendant's response must be made within a reasonable time, and that's generally 14 days in a straightforward case, and no more than 3 months in a very complex one. Usually the parties will settle on something in between, so something around about 28 days is normally an acceptable period for the defendant to respond. If we can move on to the next slide. As I just mentioned, as part of the pre-action protocol, the parties should disclose key documentation relevant to the issues in dispute. Of course, that's only going to be the documents which they have in their possession. Once the pre-action protocol has been worked through, the parties then need to take some legal advice and take stock. And once they've done that, they should make some attempt to settle the case through alternative dispute resolution. It's only once the protocol has been fully exhausted that the parties should consider issuing a claim. And on that note, I will now hand over to Gwyn, who's going to consider the procedure for issuing probate claims under CPR Part 57.
Thank you very much, Adrian. What is a probate claim? Well, strictly speaking, a probate claim is a claim in respect of any contentious matter arising in connection with an application for the grant or revocation of probate or letters of administration, and it includes a claim for an order pronouncing for or against the validity of an alleged will. It does not include a claim for rectification of a will or for removal or substitution of personal representatives in an Inheritance Act claim. There are 3 forms of probate claim. Firstly, there are claims asking the court to pronounce for or against a will in solemn form of law. Secondly, there are interest claims, otherwise known as interest suits. And thirdly, there are claims for the revocation of probate or letters of administration. What about limitation? Well, there's no statutory limitation period for probate actions. However, a subsisting probate claim may be struck out on the ground of delay in pursuing it, and that's the equitable doctrine of laches. Take care also of certain practical considerations. So, for example, if the estate has already been distributed and perhaps some of the money has been taken to or spent in the Caribbean, as the Americans call it, or the Caribbean. What are the procedural rules? Well, just moving on to the next slide, CPR Part 57 applies, and that applies to the following: probate claims, to claims for the rectification of wills, to claims for the substitution or removal of personal representatives, and to claims under the Inheritance Act 1975. Now, those are all dealt with in more detail in the practice direction that accompanies Part 57 in Practice Direction 57A. So, probate claims are usually issued in the High Court and assigned to the Chancery Division. This, since the 2nd of October 2017, has operated as part of the Business and Property Courts of England and Wales. And probate claims are in the Property, Trusts and Probate list. And if there's a significant link to a particular circuit outside London, then the claim should be issued in a business and property court district registry. The county court only has jurisdiction where an application for a grant has been made in the principal registry or a probate district registry and the value of the net estate does not exceed the county court limit, which is £30,000. Even then, a probate claim can only be brought in a county court where there's also a business and property court district registry or in the county court in central London, so that's a limited subset. In practice, it's actually rare to issue in the county court, although the High Court can transfer to the county court after the claim's been issued. The Part 7 procedure applies, with the issue form being Form N2, the claim form, and probate claims are automatically allocated to the multi-track. And when a probate claim is issued, the court should send notice to the district registry in Leeds requesting that all testamentary documents, grants of representation and other relevant documents are sent to the court. Now, this doesn't always happen, so if you are issuing, then it's worth checking that that is in process. The commencement of a probate claim prevents a grant from issuing unless the claim has been disposed of, unless the court orders otherwise. And a defendant must file an acknowledgement of service 28 days after the particulars of the claim have been served on the defendant, and that's in accordance with CPR 57.4. Now I'm going to hand over at this point to Olivia Murphy.
Looking at Procedure and Inheritance Act claims, as the procedural guides make plain, you can issue these proceedings in either the Chancery Division or the Family Division. In either case, reference should be made to the Chancery Guide 2016, and you are guided by CPR Part 57, as Gwyn just explained. The Family Procedure Rules do not provide for 1975 Act claims, and for that reason it is difficult to see why you would issue in the Family Division, despite there being express provision remaining in CPR 57 Rule 15B to enable this to be done. Claims are often issued in the county court, and that is because it has unlimited jurisdiction to consider 1975 Act claims. But if there is also a challenge to a will, then you should issue in the High Court because of the £30,000 limit for probate claims in the county court. Now, Part 8 procedure applies, and Rule 57.16 sets out the procedure. Because it is a Part 8 claim and probate claims are Part 7, you cannot combine claims at the outset on a single claim form. You must issue your challenge to a will's validity using Part 7. You must issue your Inheritance Act claim using Part 8, and then you must apply for the claims to be tried together. Use Form N208. Exhibited to the claimant's evidence must be the grant of probate or the letters of administration, and every testamentary document in respect of which the grant or letters of administration were made also must be exhibited. Remember that if you are out of time to issue an Inheritance Act claim, and you have 6 months, of course, after the grant, you must ask for permission to apply out of time in a separate paragraph on the claim form. Where no grant has been obtained before the claim is issued, the claimant may make a claim without naming the defendant and may apply for directions as to the representation of the estate. Now, the time within which the defendant must file and serve an acknowledgement of service and his evidence is 21 days after service of the claim, and that is CPR 57.16 subsection 4. Personal representative defendants must file and serve information set out in the paragraph 16 of the practice direction to Part 57, and that is details of the net estate, details of the persons entitled under the will or the intestacy, the value of their interests, whether or not any living beneficiary is a child or lacks capacity, and any other facts which might be relevant to the court's exercise of its powers. Going on to consider procedure in claims for the substitution or removal of personal representatives, and I think that's on the next slide. Section 50 of the Administration of Justice Act 1985 empowers the court to appoint a substitute for or to remove a personal representative. Proceedings must be issued in the Chancery Division, that's CPR 57.13, and although the CPR Part 57 does not expressly say so, by inference, Part 8 procedure should be used. Every representative, whether they are the subject of the application or not, must be a party. The claim form must be accompanied by a sealed or certified copy of the grant of probate or the letters of administration, or where the claim is made before the grant of probate, the claim form must be accompanied by the original or a copy of the will. Now, the claim form must also be accompanied by written evidence containing the grounds of the claim and brief details of the property in the estate, an estimate of the value and income, brief details of liabilities of the estate, names of addresses of persons in possession of documents relating to the estate, names of beneficiaries of the estate and their respective interests, name, address and occupation of any proposed substitute personal representative. And if the claim is for the appointment of a substituted personal representative rather than just the removal of one of the personal representatives, then a signed consent to act must also accompany the claim and evidence of fitness of the proposed substitute. Do you remember, and this is the case of Goodman and Goodman, that the power to replace or remove personal representatives under a will applies to a person named as executor, but to whom probate has not been granted. The same is not true in intestacy cases. Personal representatives do not become personal representatives until a grant of the letters of administration, so an application for their removal cannot be made prior to that. Also, briefly considering obtaining testamentary documents post-issue, where a probate claim has been begun, and an application may be made to a master or a district judge for the issue of a witness summons, requiring a person to bring the relevant documents to a court office to bring either a will or any testamentary document. The application can be made without notice, and it must be supported by either an affidavit or a witness statement, and that witness statement must set out the grounds for the application. Charles.
Thank you, Olivia. I'm going to deal with applications under Rule 60, Part 64 of the Civil Procedure Rules, Beddoe applications, and after that, the appointment and removal of personal representatives by the court. Part 64.2a deals with the determination by the court of any question arising in the administration of the estate of a deceased person. Common examples where this procedure is used include construction summonses, where a party asks the court to determine the meaning of a clause in a will or who are the individuals falling within a class of persons mentioned in a will, or cases where a personal representative needs an order from the court to allow the personal representative to distribute an estate in a particular way. Note here that there's a possible overlap with the limited grants available under sections 113 and 117 of the Senior Courts Act, or a grant ad collegenda bona, all of which were dealt with in an earlier webinar. Other applications might include an application for an order for the personal representative to provide accounts. Note here that administration orders, that is to say where an order is sought that an estate is to be administered under the direction of the court, are dealt with separately at Part 64.2b. If a beneficiary brings a claim under 64.2a, I should mention prospective costs orders. Here the court has power to direct in advance of the hearing that the beneficiary's costs should be paid out of the estate in any event. Case of MacDonald and Horn in 1995, the court ruled there that a prospective costs order will only be made if it is inevitable that at trial the judge would order costs to come out of the estate. Obviously that's a pretty high bar. The power to make prospective costs orders tends to be used where personal representatives have to make an application to the court because the will is ambiguous in some way or because the court's guidance is otherwise required. The practice direction has a model form of order annexed to it. Payments on account from time to time are possible, and they can be directed to be paid either on the standard basis or the indemnity basis. However, the key here, so far as I'm concerned, is that Part 64.2a is used for applications for a Beddoe order. This is where the personal representatives seek a direction that they can bring or defend proceedings on behalf of the estate, and that they should be indemnified for the costs of those proceedings out of the estate. The importance of these orders cannot be overemphasized. They are for the protection of personal representatives. Generally speaking, personal representatives are entitled to be indemnified out of the estate against all charges and expenses properly incurred by them. But they're not entitled to be indemnified if the expenses were not properly incurred. That's why personal representatives can and should use this procedure in order to avoid a later challenge, however unjustified, by a disgruntled beneficiary when the personal representatives seek to recover their costs from the estate. Note, before applying, the personal representatives should consider whether they're able to seek the consent of all the beneficiaries in writing to bring or defend the proceedings, together with their agreement that they be indemnified against costs by the estate. If that agreement is given, then of course the application isn't necessary. However, if one or more of the beneficiaries does not consent, generally the personal representative should always apply for a Beddoe order. Could I have the next slide, please? Now, as to the procedure for applying for a Beddoe order, first of all, note that the application is not made in the existing claim or a prospective claim, but rather it's by a separate Part 8 claim which is independent of the main claim. The witness statement in support must adduce in evidence all the items set out in the practice direction, that is practice direction B, from 7.1 to 7.7. These include the opinion of a suitably qualified lawyer of the prospects of success in the main claim, the estimate of value or other significance to the estate of the issues to be tried in the main claim, an estimate of the personal representative's likely legal costs of the main proceedings, an estimate of the likely costs of the other parties to those proceedings, any known facts concerning the means of the other parties to the main proceedings. Strictly, of course, that doesn't concern the merits of that action, but there's no point in pursuing a debt, for example, which might be owed to the estate and the costs of the action, if the debtor in fact has no means or assets. The court will want to know about any other factors which are relevant to the court's decision. It will want to know whether any pre-action protocol has been complied with. It will want to know whether the personal representatives have or intend to conduct alternative dispute resolution, and if not, why not? Lastly, the court requires to know what consultation has been carried out with the beneficiaries and with what result. Of course, if the proposed action is hostile litigation against one or more of the proposed beneficiaries or actual beneficiaries, then it's very unlikely that he or they will have approved the personal representative's costs coming out of the estate or even have been consulted about it. The judge hearing the Beddoe application needs all this information in order to weigh up the merits of the proposed proceedings and whether it's going to be worthwhile pursuing them. He will give particular attention to the protection of the estate and, of course, the beneficiaries. A Beddoe application is, in the first instance, listed in private, meaning that a third party cannot later inspect documents on the court file without the court's permission. There is a provision for making an application without naming a defendant in appropriate cases. Otherwise, a beneficiary to an estate with an interest which is opposed to that of the personal representative should be a defendant. Any privileged material, such as, for example, counsel's opinion on the merits of the main action, which, if the proposed main action is against a beneficiary, then obviously that is privileged and can't be seen by that beneficiary. In that event, the privileged material need not be served on him or her, and the beneficiary may be excluded from such part of the hearing which is devoted to discussion of that material. Lastly, the court may dispose of Part 64 applications without a hearing if it would save time and expense, and if it does that, the court will give permission to any parties to apply within a certain period of time in order to vary or discharge the order. Could I have the next slide, please? I'm going to move on to talk briefly about the appointment, removal and replacement of personal representatives by the court. This often arises where there's a dispute between actual or prospective personal representatives, but it also arises where beneficiaries want to get rid of what they see as hostile or poorly performing personal representatives. There are two ways to seek the intervention of the court. The first is Section 50 of the Administration of Justice Act 1985, and the second is Section 116 of the Senior Courts Act 1981. Could I have the next slide, please? I'm going to deal with Section 116 of the Senior Courts Act 1981 first. This provides that if by reason of any special circumstances it appears to the High Court to be necessary or expedient to appoint as an administrator some person other than the person who, but for this section, would have been entitled to the grant, the court may in its discretion appoint as administrator such person as it thinks expedient, and any grant of administration under this section may be limited in any way the court thinks fit. The wording of this, and in particular the wording of subsection 1, indicates that it's intended for use before a grant of representation has been made. Could I have the next slide, please? Section 50 of the Administration of Justice Act 1985 is somewhat broader, and this provides that where an application relating to the estate of a deceased person is made to the High Court under this subsection, or by or on behalf of a personal representative of the deceased, or by a beneficiary of the estate, the court may in its discretion appoint a person in this section called a substituted personal representative to act as personal representative of the deceased in place of the existing personal representative or representatives of the deceased, or any of them, or if there are two or more existing personal representatives of the deceased, it may terminate the appointment of one or more but not all of those persons. Could I have the next slide, please? Clearly this is a very wide provision. It allows either any beneficiary or any personal representative to apply for the removal or substitution of one or more of the personal representatives. Very wide discretion, and the same factors should be considered for the removal of personal representatives as in the case of removal of the trustee of a trust, as described in Letterstead and Brewer's 1884 case, which we dealt with in an earlier webinar. The key factors are the welfare of the beneficiaries and the protection of the trust estate. It's not necessary to establish fault. If the administration of the estate has become impossible, then the personal representatives will be removed. On the other hand, not every mistake by personal representatives will automatically lead to removal if, for example, they can still fairly and conscientiously carry out their duties. Lastly, note that under Section 50(3) of the Act, the court can order that a substituted personal representative be paid, even where the will makes no provision for remuneration. Since it's often the case that a solicitor is appointed as the substituted personal representative, this provision is both useful and necessary if there is no charging clause in the will, or indeed on an intestacy. Now that brings this webinar to an end. Thank you for viewing and listening to it. As you know, it was the third in a series of 4. The final webinar will deal with some of the many issues which arise in connection with applications made under the Inheritance Provision for Family Independence Act of 1975. Thank you once again. This webinar is now concluded.